Thank you very much, Melanie. Hello, everyone. It's very nice to see you all. I've really been looking forward to this event for some days, and congratulations on putting all of this together despite the current challenges that we all face. Thank you also, Melanie, for the introduction. I am definitely not sure about how groundbreaking the work is, but I do hope at least to share with you some ideas that I've been thinking about, and hopefully we could have a discussion and see how we can take this issue forward. I need to say that I'm not going to say anything about COVID-19, simply because I don't know much about, from a scholarly scientific point of view, about COVID-19. But I do hope to say something about the broader issue of how I think environmental law should change to be more responsive to the current challenges that we are facing in the Anthropocene, which of course includes also COVID-19 challenges and everything that is associated with that impulse. So my paper is about Earth Systems Law, and I will try to share with you some ideas very briefly about how I think environmental law needs to change alongside the Earth Systems metaphor. So to start with, I think it's now fairly clear that state-of-the-art research reveals environmental law's perceived regulatory gaps, its structural complicity in creating the conditions that drive the Anthropocene, such as its anthropocentric support of some privileged human subjects, its inability to halt, reverse, and remedy socio-ecological damage, and the many resultant injustices that goes with that, and its lack of regulatory ambition. Particularly relevant for today is the architecture of environmental law, including its core assumptions, orientation, operation, and objectives, which are not commensurate with the most recent understanding of the many regulatory challenges that arise from a very deeply complex and interlinked Earth system. Scholars agree that when it comes to reforming environmental law in light of a possible new geological epoch, the Anthropocene requires far more than merely tinkering at the margins. I think we all will be able to agree that we do not only require reforms currently driven by non-committal global political processes, often mostly involving high rhetoric and little definitive action, that are squarely focused on generating more, perhaps slightly revised or improved environmental laws. Such an unambitious approach remains firmly entrenched, I think, in the comfortable and very accommodative, but deeply deceiving confines of Holocene stability. We arguably need a new legal paradigm that is better fit for purpose in the Anthropocene, and that's my main thesis. And as a minimum, such a new paradigm must depart from ecological dynamism and fully embrace the Earth system's key characteristics, such as interconnectedness, unpredictability, instability, and complexity, among others. Instead of taking Holocene stability for granted, it must discard its singular focus on the environment as its regulatory object, and instead focus on the much more broadly conceived Earth system and everything that goes with that impulse. Such a systems perspective that is fully anchored in the Anthropocene's planetary context is most accurately captured, I think, by the term Earth System Law. And I will endeavor to show today that at its core, Earth System Law lies at the interface of Earth System science on the one hand, and environmental law and its associated scholarship on the other hand. At a normative regulatory level, I ultimately envision Earth System Law to be a new legal paradigm that must better respond to the type of planetary system challenges that the dynamic and complex Earth system presents, while at once offering solutions aimed at increasing Earth system resilience. At the level of scientific inquiry, I envision Earth system law to offer a framework alongside which it should be possible to critique the current deficiencies of environmental law in the Anthropocene, to serve as an umbrella concept or framework that enables a creative reimagination of environmental law for the Anthropocene, and finally, to offer and to serve as a new cross-cutting theme of scientific inquiry for scholars working in the area of law and sustainability. So firstly, what is the Earth system metaphor? In order to identify, understand, and describe the regulatory implications of the Earth system metaphor for environmental law, I think it's useful to try and understand what it means. And while some specifics may vary between different descriptions, the Earth system at its core includes a number of components and associated processes. And these include, firstly, the physical world, consisting of the geosphere, the hydrosphere, and the cryosphere. Secondly, the biological world, or all those parts that contain life. And finally, the mental world of the anthroposphere, also called the technosphere, which includes all those parts made and or modified by humans. And these components, these three components, do not exist and operate in isolation. They are characterized instead by an evolutionary continuum. The biological world emerged from the physical world, and the mental world later emerged from the biological world. And in addition to these components and processes, the system characteristics of the Earth system are of paramount importance. So what is a system? A system, the Earth's included, is seen to be greater than the sum of its component parts, which by definition implies that the combined system is somehow better than you would expect from the individual parts, because the way they combine adds a different quality. Second, causality is central to a system, any system, and is specifically evident in terms of a system's feedbacks. Now, feedback refers to a chain of cause and effect relations that form a closed loop, which in turn means that information about the past or present state of a system can influence its present or future state. So for the purpose of the Earth system, where one variable, such as ozone content or soil moisture, is affected, others, such as atmospheric temperature, will therefore also be affected. Everything is interlinked. Third, because a system is complex, unstable, and unpredictable by design, inherently by design, it continuously pursues stability or equilibrium. It continuously strives to achieve stability, often over very long periods of time. Now, the Earth system continuously pursues stability as well, while seeking to maintain conditions that are conducive to life on Earth. But where positive feedback loops hit the Earth system too hard, it might be unable to bounce back to its original state and may even be propelled into an entirely alternative state. Geological forces such as volcanoes and earthquakes are known to cause this. And now humans, as we see through the trope of the Anthropocene, are capable of interfering with the Earth's self-regulation and its equilibrium and stability. And this is the main problem. And this is what the Anthropocene tells us. Now, the Earth system metaphor departs from such a system's understanding, and it has now become a popular scientific framing and contemporary analytical framework in the domain of Earth system science to describe, understand, and respond to the complex interactions between Earth system components and processes. The evolution of the Earth system metaphor has occurred as a response to the deficiencies resulting from a traditional, linear, one-dimensional, and segmented approach to understanding and responding to what were perceived to be discrete, unrelated, localized environmental problems that only occur in specific and disconnected geographic locations. And these environmental problems seem to arise in a state of relative Holocene stability, which consequently posed minimal challenges to the type of, let's be honest, simple, top-down, unconnected, mostly state-driven, command and control regulatory institutions, which are especially apparent in environmental law, that were aimed, and that are still aimed, at tackling negative externalities of transactions, instead of also addressing structural issues underlying those human processes that cause socio-ecological damage of the entire Earth system. In stark contrast to this reductionist approach, the significantly more all-embracing Earth system metaphor instead shifts its holistic focus to the planetary scale. And in doing so, it extends Earth system science's inquiry into new areas, seeking to understand complex and dynamic human and non-human relationships, complex self-organizing systems, irreversible impacts of interacting stresses, multiple scales of organization, and the various actors and their agendas that influence Earth system change. Now, what is the relationship between environmental law and the Earth system metaphor? Although social scientists increasingly recognize the significance of humans as a driving force of Earth system changes, the relevance of the Earth system metaphor for many years largely remained confined to the Earth system science domain, which is, of course, almost fully a natural sciences domain, with very few deliberate attempts at translating its relevance and implications for the social sciences. Since the early, around about 2000s, the Earth system metaphor has been popularized in the social sciences domain by the introduction of the notion of the Anthropocene, and later by the associated image of the planetary boundaries, which reveals the deeply linked social and ecological aspects of the Earth system. Now, consequent on such initiatives, the burgeoning field of Earth system governance that has been pioneered by a colleague of mine, Frank Biermann, since 2002 is perhaps the clearest example of the Earth system metaphor's attempts to infiltrate the social sciences. And it serves as a stark contrast to environmental law and environmental lawyers' continued ambivalence towards and reluctance to fully embrace the Earth system perspective. Yet at the same time, the burgeoning Earth system governance program, I think, also offers hope for environmental law's possible eventual future embrace of the Earth system perspective. And the challenge of Earth system governance, in the words of Frank Biermann, is to respond to the serious mismatch between the research and recommendations of Earth system science analysts, the natural scientists, and the actions of political decision makers, those actions that we as lawyers can influence, who still operate within the parameters of a nation-state system inherited from the 20th century. He says that policymakers in the 20th century gained much experience in managing confined ecosystems, such as river basins, forests, lakes. But in the 21st century, we are faced with one of the largest governance challenges humankind has ever had to deal with, protecting the entire Earth system. So for their part, environmental law and environmental lawyers, including myself, have not yet, I think, meaningfully embraced the Earth system metaphor, although other social sciences have done so. And although some environmental lawyers are admittedly now extending their research into the domain of law and the Anthropocene and into transnational environmental law, which orientates more or less towards a complex, pluralistic, and holistic approach that is not jurisdictionally bounded as compared to traditional monist, state-bound, and top-down environmental law. And this is also not to say, of course, that environmental lawyers are not aware and critical of the many shortcomings of environmental law. In fact, the burgeoning body of critical environmental law scholarship suggests quite the contrary. What it does suggest, I think, is that on balance, environmental lawyers might not yet fully appreciate some of the possible far-reaching implications of the Earth system perspective for environmental law. And or they might not see the need for a wholesale new legal paradigm for the Anthropocene, and instead opt to pursue the status quo and incremental reforms of the current body of environmental law. And such an approach, we must also admit, is driven by current political trends as well. So the current disconnect between environmental law and the Anthropocene's Earth system metaphor is echoed in Frank Biermann's challenge of Earth system governance. And this is a challenge, I think, that equally applies to environmental law, not only because of environmental law's close proximity to governance and politics, but also because of its structural complicity in causing the Anthropocene. And because of the responsibility environmental law must now, and environmental lawyers must now assume to enable humans to live in and with the Anthropocene. So having said all of this, how do we get from environmental law to Earth system law? Frankly, I don't know. But I have some suggestions that one could ponder in our way towards such an objective, reaching such an objective. So Earth system governance scholars already acknowledge that the regulatory and scientific implications and opportunities of the Earth system metaphor for our social regulatory institutions will be profound. And I think there's every reason to believe that it will also pose significant challenges and opportunities for environmental law. In the little time that's left, I will highlight some of these challenges and opportunities, rather, in the hope of initiating a debate on some of the considerations that environmental law and its lawyers might possibly have to consider in their pursuit of Earth system law. And there's four. The first one, interdisciplinary co-learning and transformations. Environmental law will have to immerse itself more fully in the growing interdisciplinary Earth system science effort on which it should draw. Environmental lawyers could capitalize on existing interdisciplinary knowledge and experience by first trying to understand what the Earth system means in general terms and for environmental law specifically. Earth system science already offers comprehensive natural science-based insights into what the Earth system is and how humans and other forces impact the systems, and the type, range, and depth of possible challenges that arise from these impacts that will have to be addressed. And these insights must and can already be translated into the social world of environmental law. It has already been done in the social political world of and governance world of Earth system governance, so it's possible. Informed as such an exercise could be by the Earth system governance experience. After all, the social science domain of Earth system governance, which has now fully embraced the Earth system metaphor, has made significant headway into identifying, understanding, and designing possible governance-based responses to the regulatory issues that the Earth system challenges create. Second, relearning alongside systems thinking. So one important objective, I think, of interdisciplinary transformations would be for environmental law to reorganize itself around systems thinking. Fully embracing a systems approach would allow Earth system law to respond not only to environmental issues, but also to a far broader range of reciprocally interlinked challenges of the entire Earth system. Now, the main challenge in this respect, I suspect, would not be to transform the nature or essence of law as such. Law and its specialized regimes, such as environmental law, after all, is a system. The legal system is, to quote J.B. Rule, the legal system is a source of rules for regulating other social systems. Law is even seen to be a complex adaptive system, in the sense that it fully embraces and even depends on legal pluralism. I suspect the main challenge is more straightforward, but no less daunting. If environmental law already exhibits systems qualities, we would merely need environmental lawyers to recognize these qualities and to design, develop, apply, enforce, and revise environmental law for the purpose of governing the Earth system around systems thinking. The step change that would be required is to more fully identify, understand, further develop, and apply the systems characteristics that environmental law already has. So in short, environmental lawyers will have to relearn by going back to the basics. Relearning will ask of all of us to first and foremost reappreciate those aspects that make environmental law a system and that enable environmental law to interact with and to respond to other systems, such as the Earth system. Now, this might imply that we need to go beyond environmental law, as it were, in its present understanding, as the law tackling negative externalities, and focus on how law more generally organizes the transactions or processes that prompted the Anthropocene. By way of example, amending environmental laws to periodically increase penalties for a coal power plant situated on the banks of a river that it pollutes will always remain important as a method of deterrence. In addition, however, an Earth system approach would require holistic reforms that aim to tackle not only the negative externalities of such pollution, but also the structural processes underlying the causes of that pollution, including, for example, economic and consumption drivers that encourage development of coal power stations, spatial planning laws that allow such facilities to be built in sensitive areas next to a river, international relation and trade laws regulating the export of electricity to another country, investment laws that must ideally encourage the expansion of renewable energy plants, but they don't do so, and labor and social security laws allowing cheap migrant laborers to temporarily work for minimum wages in the coal mines that feed the power plant. So in this view, the specific localized environmental problem of the pollution of a river by a coal power plant becomes a global Earth system problem that requires a holistic response from an Earth system-oriented body of law. Third, complex adaptive law for a complex adaptive Earth system is something that we'll have to think about. The imagery of the Anthropocene suggests that we live in unprecedented times of unpredictable and extreme socio-ecological upheaval, at least in terms of the human experience, which is very, very, very short in terms of geological time, of course. So in stark contrast to the Holocene's relative harmony and predictability, the one issue that does seem to be certain in this uncharted epoch of the Anthropocene is that complexity will now become the norm rather than the exception. In other words, inherent as it is to the type of systems thinking that we've just talked about, the context of complexity is now a central premise for understanding and responding to Earth system transformations. And as a response to the need to embrace complexity, the Earth system metaphor usefully introduces the context of complexity into the regulatory and scientific debates and practices. Perhaps mainly as a result of its ontological design and its pursuit of certainty, normative hierarchy, order, structure, tightly managed, structured outcomes, as well as its organization around distinct and centralized sources of mostly public power, environmental law does not respond well to complexity. Environmental law is instead a non-adaptive heap of prescriptive and proscriptive commandments that aim to offer certainty, stability, predictability, and simplicity in a complex world. So for environmental law to accommodate and to respond to Earth system complexity, it will have to discard assumptions of Holocene simplicity and ecological equilibrium upon which it is built and from where it proceeds in order to regulate. Environmental law must instead fully embrace Earth system complexity in order to remain relevant, effective, and fit for purpose in the Anthropocene. If it fails to do so, environmental law runs the risk of losing its regulatory value because it will remain premised on false assumptions that are not commensurate with a complex Earth system reality. I offer one example. The future global climate law regime will possibly have to be far more ambitious and comprehensive in order to cater for uncertainty and to respond to extreme levels of climate harm and disruption that are not exclusively caused by climate-related processes. It must have more explicit reciprocal connections with and deliberate measures to facilitate interactions between other related international, regional, and national legal regimes. It must enable a broader scope of state and non-state actors collectively to engage in cooperative global climate governance that is not territorially bounded and jurisdictionally circumscribed. And it must be more flexible and adaptive in relation to achieving its ultimate objective of global sustainability. To this end, an Earth system-oriented global climate law might have to consider and address all at once many other issues that are related to global climate change, such as stratospheric ozone depletion, loss of biosphere integrity, ocean acidification, to name only a few. And for this purpose, an Earth system-oriented legal response to global climate change, which is one of the 9 planetary boundaries, could be achieved by holistically, for example, considering the many aspects regulated by the laws pertaining to all of the 9 planetary boundaries. And finally, we need to bring humans back into the Earth system. To the extent that the Earth system metaphor illuminates how deeply intertwined the biosphere and geosphere are, it dissolves Cartesian dualisms and epistemologies of mastery, as Sam Edelman says, by reconnecting humans with an externalized, submissive, and compliant female nature somewhere out there that can be managed by Promethean humans. This is problematic because such a recognition is occurring consequent on the Earth system metaphor's imagery of interconnectivity, the Anthropocene's emphasis of humans as being part of the Earth system, and the associated awareness of the profound role and power of humans in actually transforming the Earth system, alongside a realization that how we use this awareness will shape the Earth's future and the future for all life on Earth, not only our own. And such a perspective consequently shows that the Earth system is vulnerable and that humans are also vulnerable as a result of our own doing. We are merely a small, but evidently very, very influential part of the vulnerable Earth system. Yet we are neither as invincible as we think we are, nor are the social rules we design to maintain deliberate patterns of advantage for a few able to maintain such selective privilege forever. The Anthropocene instead exposes the fraud and the deception by which a highly selective group of privileged, consumptive, and exploitative humans have been masking their co-responsibility for Earth system destruction. A destruction that has and that continues to be facilitated also by environmental law, as some critical legal scholars point out. In fact, we need to acknowledge that as a privileging human construct that benefits some privileged humans, anthropocentric environmental law and its associated constructs and paradigms such as property law, colonialism, slavery, state sovereignty, and even human rights have been complicit in causing the Anthropocene and its predatory forms of exploitation of a vulnerable Earth system and its most vulnerable segments of society. So the implications of such a realization and the need for new imaginations, I think, and I suspect, could and will shake environmental law to its core. In addition to becoming systems-oriented, environmental law will arguably have to be more sensitive and responsive to Earth system vulnerability. An Earth system vulnerability is an all-embracing notion that potentially includes the human and non-human elements of the entire Earth system, by explicitly emphasizing the fact that human vulnerability is ontologically intertwined with non-human vulnerability. Earth system law will accordingly have to recognize and fully cater for Earth system vulnerability in its fullest sense. And one way to do so is to discard assumptions of human mastery that anthropocentric environmental law still continues to underwrite, and to cease benefiting only a selective privileged few humans, generally seen to reside in the global north, at the expense of those humans and their exploitable resources, which are exploited by the global north, of the people residing in the global south. So Earth system law must also be more focused on protecting non-humans in addition to this, not because such an endeavor would benefit humans, but because Earth system law must adhere to an ethical obligation to address Earth system vulnerability in its widest sense by extending juridical care to law's non-traditional subjects. In conclusion, the Earth system metaphor, I think, challenges us to discard what we think we know about environmental law's role in addressing the many regulatory challenges emanating from a complex Earth system in the Anthropocene. To this end, the Earth system metaphor, for me at least, suggests that we need a new legal paradigm for the Anthropocene. This new legal paradigm need not necessarily become a distinct new field of law. It could over time, but it need not. For now, I think Earth system law could merely represent a framework for rethinking environmental law for the purpose of the Anthropocene. And such a new legal paradigm will require considerably creative, out-of-the-box thinking, alongside the imagery of the Earth system metaphor. And this will not be a straightforward process. After all, as Crispin Tickle says, little is more difficult than learning to think differently. Yet, it's hard even to define the principal problems without upsetting long-standing traditions, beliefs, attitudes, and the often unspoken assumptions on which we build our lives. And this is true for environmental law and for environmental lawyers as well. Are we willing and will we ultimately be able to upset our traditions, beliefs, and attitudes when it comes to thinking about a different type of legal paradigm that is better fit for purpose in the Anthropocene? I really hope so. Thank you.